Not in a vague, abstract way, but concretely, specifically. What would actually be at risk if a tenant, a contractor, or a creditor decided to take you to court and won? If you own property in your own name, the answer is deeply uncomfortable. Because the answer is everything. Your home, your savings, your pension, your children's future. Every asset attached to your name becomes fair game the moment a judge rules against you. And the truly alarming part is that most property investors have absolutely no idea this is their reality. They have spent years building a portfolio, sacrificing weekends, navigating interest rates, managing tenants, and growing their net worth, all without realizing that everything sits completely exposed. Today, we are talking about the #1 mistake that leads to catastrophic lawsuits. It is not a complicated mistake. It is not an obscure legal technicality. It is something the vast majority of investors are doing right now, today, without a second thought. And it has the power to unravel everything in a single courtroom session. Welcome to the Wealth Guardian, the channel that bridges the gap between complex legal jargon and practical real-world asset protection. The goal here is simple: helping you keep what you have worked so hard to build. If you are a property investor or a family looking to secure your legacy for the next generation, this channel was built for you. Hit that subscribe button and turn on notifications. New wealth protection blueprints every single week. Before we go any further, an important reminder. Everything in this video is strictly for educational purposes. Nothing here constitutes legal or financial advice tailored to your personal situation. Always consult a qualified solicitor or financial professional for guidance specific to your circumstances. What this content is designed to do is help you understand the landscape, so that when you do seek professional advice, you are walking in informed and prepared. Now, let us get into it. The #1 mistake that leads to devastating lawsuits is this: holding your assets in your personal name with no legal separation between your investments and your personal wealth. In other words, keeping everything in one bucket. It sounds straightforward, almost too simple to be the catastrophic mistake we are describing. But that simplicity is precisely what makes it so dangerous. It does not feel like a mistake. It feels like the natural way to do things. It feels manageable, logical even. And that is exactly why nearly 90% of property investors are doing it right now. Let us break down how this happens and why it creates such enormous legal exposure. When most people buy their first investment property, they buy it in their own name. The reasons are understandable. Personal ownership is simpler to set up. Mortgage products for individual buyers are often more accessible. The administrative burden is lower. And when you are just starting out, the idea of setting up corporate structures can feel like overkill, something reserved for large developers or institutional investors, not someone with 1 or 2 properties. So they buy in their own name, and then they buy another, and another. Each time, the same reasoning applies. It is easier. It is cheaper in the short term. It is what most people around them are doing. And slowly, without ever making a single conscious decision to do so, they end up with an entire portfolio, sometimes worth millions of dollars, sitting completely exposed in their personal name. Here is what that actually means in legal terms. When you own property personally, you and that property are legally the same entity. There is no separation between you as an individual and you as a property owner. The law does not draw a distinction. It sees one person with one pool of assets, fully responsible for everything connected to those assets. So when something goes wrong, and in property investment, something always eventually goes wrong, the legal exposure does not stop at the property itself. It extends to everything you own. Let us make this concrete. A tenant in one of your properties slips on a staircase and suffers a serious injury. They sue you for $1 million. The court finds in their favor. That tenant's legal team is not limited to pursuing the value of that one property. They can come after your personal home. They can pursue your savings accounts. They can reach into your pension. They can go after every asset that carries your name, or consider a contractor dispute. A building firm claims they are owed $50,000 for work completed on one of your properties. The dispute escalates. It goes to court. You lose. The same principle applies. Your personal financial life becomes the battleground. Or a mortgage lender, a dispute with a creditor, a regulatory fine. Any one of these scenarios in the context of personal ownership creates a direct line of liability straight into everything you have built. This is the everything in one bucket problem. Every asset, your investment properties, your family home, your savings, your pension, your car, all of it sits in a single, legally undivided pool. One successful lawsuit, and someone else gets to reach into that pool and take from it freely. And the more properties you add to your portfolio, all held in your personal name, the worse the problem becomes. Because now every property is a potential source of liability. Every tenant interaction, every contractor relationship, every compliance issue carries the same catastrophic downside, the potential loss of your entire personal wealth. This is not a theoretical risk. This is a routine legal reality that plays out in courtrooms across the country every single year. People who worked incredibly hard, built something genuinely impressive, and lost it because they never addressed this one fundamental structural vulnerability. So let us talk about how to fix it. The solution is called asset isolation. And the principle is straightforward. Instead of holding everything in one bucket, you create separate legal containers for your assets, so that if one container is attacked, the others remain completely untouched. The analogy that captures this most clearly is a submarine. A well-engineered submarine is not one large open compartment. It is divided into multiple sealed sections. If the hull is breached in one area and water begins to flood in, the crew seals the door to that compartment. The flooding is contained. The rest of the vessel stays dry. The ship continues to operate. The crew survives. Your property portfolio needs to be built with the same logic. Each asset or each group of assets contained within its own sealed legal compartment. A breach in one area cannot spread to the others. In practice, this is achieved through legal structures, most commonly limited companies or trusts. For property investors, the most widely used structure is the Special Purpose Vehicle, or SPV. This is a limited company created specifically and solely for the purpose of holding property. The company owns the property. You own the company. But crucially, the company is a separate legal entity. It can enter into contracts, take on liabilities, and face lawsuits, entirely independently of you as an individual. This separation creates what the law calls the corporate veil. The corporate veil is the legal barrier between a company and the people behind it. When a properly maintained company faces a lawsuit, that lawsuit is directed at the company, not at you personally. Your home, your savings, your personal financial life sit behind the veil, protected. If a tenant sues the company that owns the property, they are suing the company. The company's assets are at risk. Your personal assets, in most circumstances, are not. If a contractor pursues a legal claim against the company, that claim is against the company. The company's finances are exposed. Yours are not. This is the fundamental shift from personal exposure to corporate containment, from one bucket to multiple sealed compartments. And for investors with larger portfolios, this logic can be extended further. Rather than holding all properties in a single company, more sophisticated structures use separate SPVs for different properties or different categories of risk. If one company faces a serious legal challenge, the other companies, and the assets within them, remain entirely insulated. Now, this is where a critical warning becomes necessary, because this is the point where many investors make a second, equally serious mistake. They set up the company, they transfer a property into it, and they assume the job is done. They believe the corporate veil is automatically and permanently in place simply because the company exists. It is not. The corporate veil is not a static shield. It is a legal construct that must be actively maintained. And there is a specific legal doctrine that opposing lawyers use to destroy it. It is called veil piercing, and it is triggered by something called commingling. Commingling is the blurring of the line between you as an individual and your company as a separate legal entity, and it happens far more easily than most people realize. You use the company bank account to pay for personal expenses, a weekly grocery shop, a family vacation, a car service. These transactions seem minor, but each one creates evidence that the company is not truly operating as an independent entity. You fail to hold proper board meetings or maintain adequate meeting minutes. You do not keep separate accounting records for the company. You move money freely between the company and your personal accounts without proper documentation. You make decisions on behalf of the company without following the correct corporate procedures. Individually, any one of these might seem trivial, but collectively, they build a picture that a skilled opposing lawyer will use to make a very specific argument in court. They will argue that your company is not a genuine, independent legal entity. They will argue that it is simply your alter ego, a corporate mask with nothing real behind it. They will present the evidence of commingling and ask the court to treat the company and you as legally identical. And if the court agrees, if the veil is pierced, every protection the corporate structure was supposed to provide is gone. Instantly. Completely. The lawsuit no longer stops at the company. It passes straight through to you personally. Your home, your savings, your personal wealth, all of it back on the table. This is not a rare outcome. Courts pierce the corporate veil when the evidence of commingling is strong enough. And opposing legal teams are specifically trained to look for exactly this kind of evidence. The lesson is non-negotiable. If you create a company as a legal structure for asset protection, you must run that company as a genuine, independent legal entity. Not sometimes, not mostly, always. Separate bank accounts, rigorous and complete financial records, proper board minutes, clean documentation of every significant decision, a complete separation between company finances and personal finances in every transaction, without exception. Treat your business like a business, because if you do not, the law will not treat it like one either. And at that point, everything you put the structure in place to protect becomes vulnerable again. So let us bring all of this into a practical, actionable framework. Because understanding the problem and the solution is only valuable if it leads to concrete action. Here is your 3-step Wealth Guardian checklist. Step 1. Audit your current position. Sit down this week and map out every asset you own. How many properties are currently held in your personal name? How many, if any, sit inside a corporate structure? What is your actual legal exposure right now if a lawsuit were filed tomorrow? You cannot address a vulnerability you have not clearly identified. This audit costs nothing but time and is the essential foundation of everything else. Step 2. Review your insurance coverage. Asset protection is not only a structural question, it is also an insurance question. Do you have adequate landlord insurance on every property in your portfolio? More importantly, do you have an umbrella liability policy that covers the gaps between your individual property policies? Many investors discover significant holes in their coverage only when they need it most. A conversation with a specialist insurance broker this week could close gaps that you currently do not even know exist. Step 3. Consult a specialist. This is the most important step on the list, and it is non-negotiable. Asset protection structures are not generic. The right approach depends entirely on your specific circumstances. Your current portfolio, your tax position, your family situation, your long-term objectives, and the level of risk your particular investments carry. What is the correct structure for one investor may be entirely wrong for another. You need a solicitor who specializes in asset protection and property law, not a generalist, a specialist. The cost of getting proper professional advice is always significantly less than the cost of getting this wrong. Let us consolidate everything covered today, because the stakes are high enough that the key points are worth restating clearly. The number one mistake that leads to catastrophic lawsuits is holding your assets in your personal name, the everything in one bucket trap. When everything sits in one pool with no legal separation, one successful lawsuit can expose your entire personal wealth. The solution is asset isolation. Using legal structures like limited companies and SPVs to create sealed compartments around your assets so that a legal challenge to one compartment cannot reach the others. The warning is that the structure only works if it is properly maintained. Commingling personal and business affairs gives opposing lawyers the tools they need to pierce the corporate veil and destroy your protection entirely. And the action this week is your 3-step checklist. Audit your exposure. Review your insurance. Consult a specialist. None of this is complicated in concept, but all of it requires deliberate action. The investors who are genuinely protected are not necessarily more successful or more sophisticated than the ones who are exposed. They simply took the time to address this one fundamental question. Not just how do I build this, but how do I make sure I keep it? Next week, there is another critical layer of protection to address, one that most people assume they have already handled. Why a will on its own is often not enough to protect your estate, and why a trust could be the missing piece of your entire wealth protection plan. That video could save your family significant money and years of legal difficulty. Make sure you are subscribed so you do not miss it. If this video gave you clarity on something you had not fully considered before, please hit the like button. It directly affects how many people this content reaches. Share it with a fellow investor or anyone in your network who needs to hear this message. I've linked the professional services I recommend in the description below to help get started today. Subscribe if you have not already, hit the like button and notification bell, then please drop a comment below. Every comment gets read and every question matters. Thank you for watching. This is the Wealth Guardian, and I'll see you in the next video.